Wake up, praise Allah, it's a beautiful day. Family, friends, and fun. What more can I say? More is culture everywhere, it's all on display.
Long, but we using it to invoke the common law court and not paying attention that it's telling you where you go to invoke the damn common law court. It's in maritime because where else is there in Article 3? What?
Supreme Court? Article 3 court.
What?
Article 1, this is small courts are Article 3 courts. Tribunals are Article 3.
All of them are under a corporation.
Yeah.
They're all legislative.
Yeah.
The only place
Hawaii and DC.
Article 3 court is found today. Is Admiralty Maritime not found in Article 3?
Yep, international waters.
Is Admiralty Maritime not found in Article 3 of the Constitution? Okay, I'm like, okay, was that a trick question or what? It's common sense to recognize that this is the only place we could go to invoke a common law court. Because Admiralty Maritime is under Article 3. So if we having conflict between multiple nations here, Admiralty Maritime is there to what? Resolve the dispute between the two entities. And Admiralty Maritime says that you must bring what? A contract.
Compel.
That's where Clearfield Trust Doctrine was established. The work has already been done for us. That's where Clearfield was established, in Admiralty Maritime, the jurisdiction of the law of contracts. In general, it is a body of law that develops and derives from judicial decisions as distinguished from legislative enactments. The common law is all the statutory case law background of England and the American colonies before the American Revolution. It consists of those principles. And see, they put stuff like this in these laws, such as this. Exactly. To keep enforcing that, all of this started with the colonies. It consists of those principles, uses, and rules of actions applicable to government and security rights of persons and property which do not rest upon the authority, upon any express positive declaration of the will of what? Legislature. That Article 1 madness. They're telling you right there. This ain't got nothing to do with the legislature. It's dealing with Article 3 law. Yes, sir.
But I was under the impression that when you're dealing in Admiralty Maritime, that's basically for fictions. And when you're dealing with common law, you're dealing with flesh and blood. So even though if you go to Admiralty Maritime invoking, well, I'm assuming is that where you go to invoke the common law to get you back on the out of odds and into solid ground.
Okay, you just said it. Out of odds.
Right.
Those courts are represented in land of odds. The Admiralty is where the common law is still standing.
That's color of law. Courts are saying that's color of law.
Right. The land of odds over there, the ones that call themselves judicial courts.
Right, that's color of law.
They're all Article 1. And it's, when you get the clarity and see what's going on, it's just like I made the statement that the U.S. Marshal is the only constitutional police force that's out here. And he's still under the Constitution. Admiralty Maritime is the only constitutional jurisdiction that is still out here. And it made sense to me, especially when I found all the powers of the marshals under Admiralty Maritime. Because that's where you go to get the Constitution enforced. That's where you go to get all your writs enforced and everything else. You can request the marshals to make arrest on your behalf. Because guess what you walked over there in that venue with?
But you have to go back in the Admiralty Maritime to have him to function, right? Because I'm saying you trying to go into common law. You use the Admiralty Maritime to go into common law.
The common law is in the Admiralty, is what I'm trying to get you to see.
Okay.
They put up a nice cloak that's causing us not to see, because when you listen to the good old boys, and they're constantly talking about what Admiralty is, they're speaking of it over here.
But I thought in the Constitution, they make a difference between the two. They call it law and equity, which is still Admiralty Maritime, and then the other one is common law. So it's you know, I thought they were separate. Now you're saying they both are into one.
Here's what I'm saying. I gotta go through that door. I'm in this room, but the other room that I need to get into is on the other side of that door. So for me to get out there to that cafeteria so that I can get some grub or whatever, I need to walk through that door. Now, I didn't know that there was a cafeteria there. I didn't know that that door could lead me to the cafeteria, therefore I've been hungry for quite a while. But you brought it to my attention that if I go through that door, I can access the cafeteria and get me some grub. They have cloaked Admiralty as being the Uniform Commercial Code and judicial courts, when it is not. This is the bankruptcy de facto here. Listen, this is where the de facto is still operating, because it is still claiming you as its what? 14th Amendment property. Now, for me to get out of the jurisdiction of this facto, where I can stand and deal with the law of nations, I done issued my flag, but it's all being ignored here. Because this is a de facto corporation still trying to impose. It's using slavery. In their jurisdiction, slavery is allowed. You know that. We done went through all of their codes. This other venue deals with the disputes of all the nations when this de facto is trying to impose. So there's, in other words, for me to actually acquire the justice that I'm looking for under common law, this is the venue where it is held. Admiralty exists in common law. It is in the Constitution under Article 3. It is an Article 3 court. Are you with me? Even though it's Admiralty, it is still authorized under what? The Constitution. This one here that's calling itself a court has no judicial power whatsoever because it is legislative. And this is where the problem is. Now look how you're perceiving it right now. You calling this a court. It ain't. But you, Admiralty, which is the proper court, you're saying no, it's not possible.
It's one of the proper courts.
It is the only proper court. Because there's a bankruptcy here.
Right. That we're functioning in. Because I'm saying, I'm going back to the past. I'm going back to the, as you say, the organic constitution. So
this is in the organic.
Right.
It's authorized. Read Article 3 of the Constitution. Can you grab a Constitution out of there?
Maritime is authorized.
Right. No. That's what I'm saying because it calls equity. Equity and common law. They just both the same as authorized in the Constitution.
No. Over here is what they're calling it. Over here is what they're saying is all combined. And it don't matter. But every time you ask, okay, is this statute? What is it? They will not answer. Because if it's a statute, it cannot have any criminal fines attached to it. So they're taking all of this and mixing it all up and applying common law leans to it. Because under common law, you can have when there's an injured party, there can be a fine and a incarceration. If you done injured me and harmed me, I can have you charged criminally and civilly. So over here, there is no injured party ever, but yet and still, if you don't pay that driver's ticket, they're going to what? Issue a fine and arrest you. It's not lawful under common law for this process to take place. Because we done put up all the statutes in Michigan, and it says that a violation of a statute or code of ordinance is not a arrestable offense, nor can there be a fine attached to it. So then why the hell do people go to jail for seatbelts and traffic citations? Because over here it's allowed. It's de facto, and we can do what we want. It's a quasi-admiralty, but over here, the common law under Article 3 is still being regulated. And they confuse us here, making us think this is the admiralty, so when we do get a clue, it ain't clicking. This has been the whole scheme to give this the illusion as being a court. And we can't break it. And over here is the real court.
And still, like you said, and over there, that admiralty still has to be harmony with the Constitution.
It is.
That's
Hold
what
on.
I'm saying, right, yeah, it has to be in harmony.
It's stated in the Constitution.
Right, where on that side it's not.
Ain't no way.
Right.
That's why they threaten you with contempt of court when you try to come in there with the Constitution. Over here, I'm telling you, they even tell you your right to bear arms is protected over here. The Constitution is here. We have just been misinformed as they do a damn good job. Yes, sir.
What seems like what they've done is that they have confused us
Yes.
with terminology again.
That's the game.
Because we're
Scroll up,
thinking that quasi-admiralty is the same thing as admiral,
Yes.
Right.
Right. And quasi mean what?
seemingly.
The
As the-
color appearance, exactly.
Colorful.
And that's been their whole game, is giving us the appearance that this is the court, this is law, and it's nothing but private contracts being enforced by pirates.
And it's not even admiralty.
It's not.
Right.
It's not.
Not at all.
Because where's the contract? You asking the contract, they gonna look at you goo-eyed. What the hell are you talking about a contract?
It's quasi.
That's the game. Is keep giving you the appearance. Oh man, come on, I got a pot of gold. They poured some paint on them rocks. But it looks like gold, so we chasing the pot. And all the while, we left the gold at home. We already had the gold. Judiciary Act, where was I at? Exclusive jurisdiction shall have exclusive of the courts of the several states. The Constitution provides that the federal judicial power shall extend to all cases. What? Admiralty, maritime jurisdiction. U.S. Constitution, Article 3. It's right there. This has nothing to do with the Constitution.
That's the straw created, when we went bankrupt.
Exactly. And it convinced us
That's
that
the
this
straw
is the
government.
This is the corporation. Stop calling it government. It's the corporation. Pretending, giving the appearance and the illusion of the government.
So, when the Patriots tell you that you have to go back over there to make sure you're given due process, your 3 notices, that was the due process.
Mhm.
So, you don't have to go back over
No.
to that court to do anything. You can go straight to your Article 3 court with confidence, knowing you have given your due process, you're standing firmly on your ground, and there's nothing they can do to you.
Absolutely.
Is that what you are saying?
That's what I'm saying.
That's what I'm understanding.
When you go over here, there's nothing they can do. They have no authority. They are butt naked here.
That's what I'm understanding.
And that's why they do not, that's been the whole smoke screen, is to keep us over here arguing.
And your
Because as long
rights
as you over
after
here,
default,
you are belligerent, and you are what? A slave.
vulnerable to
Slaves ain't got no
anything they
rights.
do to you.
You're
Exactly.
dishonored.
You're in
It
dishonor.
is,
So your
Big
rights
time.
after default come on this side, under your Article 3. And they are totally constitutional. Everything that, when people read rights after default, first time, I heard you in here, but I didn't hear you
I know a lot of people don't
until I
hear you.
read it.
Bingo. See, that's what
And
it
after
takes.
I read it several times,
You said, well, what the hell
Do
am I
you
trying to
know-
do a notarial protest for?
how powerful that makes one,
I've been saying that for
but I did not hear
5
you.
years. I
Well,
know it.
I didn't know you for
But
5
you
years.
read it, and that's when you got
When
it.
I finally got your book and I read it
And
and
I
I
asked
reread
people,
it,
10 minutes of your time a day will make you so powerful. I didn't come here to hold hands to be anybody's little dictator. I simply came to offer some truth and to help us empower ourselves. That's my only mission here. Yes, sir.
So you're saying that, do you not, or do you have to do your expatriation to get from out of the democracy into the republic? in
Yes,
order-
you ain't finna not do your expatriation, because you gonna shut down all assumptions and presumptions. You ain't finna sit by and allow them to make no assumptions. So that, and here's what when that is done, your power over here has just increased. Because now you're entering into the law of nations, the court that deals with disputes between nations, and you come in with a contract to show that they're liable. And under Admiralty Maritime, I can show you all day long, none of these suckers exempt.
Does that expatriation, repatriation goes, you send that to the U.S. Treasury?
We're not going there yet. We're dealing with administration process, okay? Patient, Jedi. Patient. But that gives you that much more power when you step in this venue, because you now have evidence that they've been noticed. So you now are dealing with what? Violation of the law of nations. And even that is in the Constitution. Everything I have given you guys, I put in here, point for point. We got law of nations pieces in here. We got the Articles of Confederation, saying that there shall remain of what form of government?
Republic.
And all of this stuff is important. All of it. Just like the flag is extremely important in giving notice. And I slept that one for a good while. I apologize. I ignored it. It's been in my face for 10 years. But I just didn't enforce it until it clicked. The flag is a notice. And the proper flag. And I've heard it for the longest. But again, if I didn't put the energy into reading the law of the flag.
We need
That's why the courts
need to
make sure
spank
they
people.
fly the flag with the fringes around. So it's distinguished.
And then you got notice when you step in there. So when you enter your paperwork, what should it have? Your notice, exactly. Exactly. If you guys ain't using these terms, the law of conflict, private law in your paperwork, you're not doing it proper. All this stuff is up there for a reason. You're giving them notice that you're not subject, and you got everything in your possession to support it, so that when they create the violation of the law of nations, you got it. Yes, sir.
So looking at this section 3 of the expatriation of 1868, man, that means that once you do your expatriation, that the president is supposed to put on his hat as the de jure president in order to assist you in taking care of your business, because you have been unjustly transgressed by the democracy or the corporation.
President of court or judge.
Oh, well, it's going by what? No, but still, I'm assuming he's wearing two hats, because he still technically is supposed to be.
And so are you.
Well, yeah. But that's what I'm saying. So that's what, like I said, if you being unjustly,
Where's his authority under?
come on, 10 square mile.
And where else?
The-
Article 1. He's legislative. He's the commander in chief, right? All his authority come under Article 1. Congress authority comes under Article 2. Judicial authority comes under Article 3. So this,
I accidentally closed the document. Here we go. Back.
Expatriation Act mentions the president.
Right? Are we here?
right, yeah. Let me read the rest of this.
It says
The
Yeah,
judiciary,
he's supposed to stand up there. Let's see. You want me to read this?
go ahead.
Okay, section 3. And be it further enacted that whenever it shall be made known to the president that any citizen of the United States has been unjustly deprived of his liberty by or under the authority of any foreign government, it shall be the duty of the president forthwith to demand of the government the reasons for his imprisonment, and if it appears to be wrongful, and in violation of the rights of American citizenship, the president shall forthwith demand the release of such citizen. And if the release so demanded is unreasonably delayed or refused, it shall be the duty of the president to use such means not amounting to acts of war as he may think necessary and proper to obtain the effectuate such release, and all of the facts and proceedings related thereto shall so as soon as practicably be communicated by the president to Congress.
You're reading from,
Expatriation Act.
Expatriation
Yeah,
Act.
Section 3 of Expatriation Act, July 27th of 1868. Section 3.
But, going back again, you ain't gonna get to the president. What you gonna end up doing is notifying the president via the secretary. That's just the protocol. But you can petition. You're absolutely right. I forgot that portion of it. But again, that's where you're gonna go to get the quickest redress. And I'm glad you read that, because that's a very important piece in the relationship, because I got it in there, but I don't have the full language. Just the expatriation, speaking that no one can speak again. It's actually a violation for any government official. And again, that's what when I said, once you got that expatriation in your possessions and you step in this venue, everybody is liable who opens up their mouth and speak against your expatriation. Because y'all done heard all them good old boys talk about, we was at some meeting and the dude was talking about expatriation, and he said, yeah, we got him and we took you to Mexico and we left you in Mexico. Now you expatriated. And I'm like, wow. It's just amazing some of the, pardon my expression, the shit that people come up with based on their opinions as opposed to the law. And the other amazing part of that is we gravitate right to it. Yeah, that's right. This dude is authorizing we're giving authority to opinions every day as opposed to facts. Well, man, why would you want to expatriate? Because they can take you and put you out of the country. I don't want to live in D.C. anyway. Shit, it's only 10 blocks.
I'm already out of there.
Again, our greatest problem is our mindset. And we have to work at changing our minds. None of this is going to matter. If you're trying to put some new wine into an old flask, it's going to eventually what? It's going to break. Book said there has to be a renewing of the mind, and I say that, y'all, because we have to find a way to break our conditioning, our belief system. We get into so much belief and very little validation. I had a call this morning, and the sister was trying to dispute with me the history of religion, and I started with the pyramids. And I said, sweetie, I'm going to Aquinas College for almost 10 years. It's a school of theology in Grand Rapids, Michigan. And they invited me every year for about 7 years to come and speak to about 400 to 500 Caucasian students, and the majority was maybe 50 to 80 African Americans. And none of the white kids had problems with me presenting information that if Jesus existed, he would have been big nose, dark skin, melanated, kinky hair. It was only the black students who was angry, mad, and pissed at me. And most of the Caucasian students had the very books that I referenced from. And we are good for arguing opinions and beliefs, and they went nowhere. Now I say, sweetie, I have visited pyramids in 4 different countries so far. I've been to Sudan, I've been to Egypt, I've been to Ethiopia. I've covered most of the pyramids in the United States and some in South America. Where have you been? And what have you read? But you're debating. You have a good day. I didn't even hang the phone up, but I did. I had to get ready to get up out of there. But that's what we do on a regular basis. And be adamant. You can't tell me, dude, I know this. Because if I just kept that mindset, I'd have slumped this, and I didn't. Eventually I caught it. The emphasis language is known as the saving to suitor clause. This provision, in its modern expression at Title 28, Section 1333(1), which reads, the emphasis added, wherefore, where is the, he's not looking. Scroll up, Head. Scroll up some more. For some more cases. Oh, this clicked on not the right one.
That's Myron.
Yeah, this, I know there's two of them, it's another one in there. It's got some more cases, there should be another one in there. Judicial notice one, motion to compel, hold on up. Default, dismissal, judicial notice here, they saved the suit, that's it. Right there. Scroll back down.
Where we going?
Back down to save the suit.
Same, almost
Yeah,
same
okay, go
location.
back up, you went too fast. This is why I'm looking for the highlighted pieces. Hold on, go ahead and do that part. Enlarge it. Go to 150. Come on up, son. Moving too fast. Oh, give me this paragraph here. Okay, have sought redress in Admiralty when property brought the suits is against the owners of vessels and estates where there are attachment laws. Plaintiffs may attach any property not exempt from execution belonging to. I'm gonna give y'all, we're gonna look at one of the codes that shows you that none of these cats is exempt from lawsuits. Saving to suit in all cases, right of common law remedy where the common law is competent to give, and the district court shall have exclusive original cognizance and culpability of the United States to protect your property rights in all seizures on land. First Judiciary Act, Chapter 20, page 77, September 24, 1789. Come on up. Come on. Come on. Stop right here. Hang on. Right here. Title 28, Section 1333, in any civil case of admiralty or maritime jurisdiction, saving to suitor in all cases, in all other remedies, they are, to which they are otherwise entitled. Come on up. Here's a clue to what it means. Saving to suitor in all cases, the right of common law remedy where the common law is competent to give it. Holmes Insurance Company versus North Parker. Look up the save to suitor clause in the Admiralty Maritime Statute, and you will find that the save to suitor can have his case, even if it is Admiralty Maritime jurisdiction, transferred to state court having common law jurisdiction. With these tools available, how can they be expanding Admiralty Maritime? Come on up. The Constitution provides that the federal judicial power shall extend to all cases of admiralty and maritime jurisdiction. U.S. Constitution, Article 3, Section 2, Clause 1. Federal courts' jurisdiction over such cases, however, has never been entirely exclusive to the Judiciary Act of 1789, which means you can even, under admiralty maritime, you can invoke a state court into admiralty maritime, which would make them poop on their pants. Because this is where the nonsense goes on. You can invoke admiralty maritime even on the state level under the Admiralty Maritime Act, the Save the Suitor Clause. That the district court shall have exclusively of the courts of the several states, exclusive original cognizance of all civil cases of admiralty maritime jurisdiction with their respective districts, as well as upon the high seas, saving to suitor in all cases the right of a common law remedy where the common law is competent to give it. Subsection 9, First Statute 76-77. The emphasis language is known as saving to suitor clause. The provision has its modern expression in Title 28, Section 1333. Your common law right is protected right there in that federal code. And it's in admiralty, which is under the Constitution. It is the only place where the Constitution is still in force and the common law rights are being exercised and protected.
So when do we want to take it to the state court instead of, what is the thing, Imperial?
When do you want to take it to the state court? What do you mean?
Well, they're doing it. Just what you just read.
I don't ever want to take it to the state court myself.
Okay, that's what I'm asking.
This is not a state court, first of all. I'm going to exhaust my administrative remedy,
Okay,
and then I'm going to proceed to enforce my contract in Admiralty.
okay. I'm
That's
still
my
with you.
plan.
Okay, no, we're together. I just had to ask.
Because I got a
Did you turn it
contract,
off? Turn it off yourself. Turn
I
it
got
off.
a private contract, and I got a dispute between another nation who's trying to impose its jurisdiction on my having behind. And it's not working for me. All right, let's go back to the earlier piece we had before we went into the disclaimer.
That's my room.
Yeah, close that out. Go back to the disclaimer. The disclaimer is actually the foreign law piece.
Was it, the expatriation was up there.
Cancellation, scroll over.
Power of
Scroll
acceptance.
over. Disclaimer right there. Okay, scroll down, let's go back into, see if I can walk y'all through this understanding, you don't know me. Let's go back, let me read the conflict of law right there.
Up.
Yes, go to the beginning of it. Conflict of laws. Inconsistency of differences between the municipal laws of different states or countries arising in the case of persons who have acquired rights or status or made contracts or in accrued obligation. Rights, status, contracts. When you expatriation, you change your status. And you done told these fools over here you're not subject, but they want to impose their rule on you anyway. So now, you're going over here to show that we have a dispute. One nation is trying to impose its authority and jurisdiction upon another. And if there's no contract, they do not have that right. They're now liable. The incurred obligation within the territory of 2 or more jurisdictions. The United States is a foreign corporation with respect to a state. The United States is a foreign corporation with respect to a state. So that piece you read, dealing with expatriation, should be able to contact the president and have him come and get you out of the county.
Right. What is emissary?
Exactly. And that is the deal, because we're dealing with it. You're right, he does wear 2 hats. He often fails to put on that one. But he does wear 2 hats. Because, and this is the thing, y'all, people keep saying that the Constitution is disbanded, is this and that, it doesn't exist. If that was the case, why would we have a conflict between 2 jurisdictions? What are the 2 jurisdictions that the conflict is in?
Under the Constitution, or acknowledging the Constitution, and the one that said they.
We have one that is non-constitutional
Yes.
and ain't interested in the Constitution. So where is the Constitution in?
In the Republic.
In the who?
In the Republic,
And where's the Republic?
on the land,
People.
in the people.
Okay, okay. Just need to hear the right terminology. What's the
Okay,
right
all right.
terminology? It ain't in the land, because the land ain't finna get up and say nothing to the court.
I'm tripping over my own words.
The mindset of the people have to understand, when they say a Republican form of government, what does that mean?
We are the Republic,
The Republican form of government, what does it mean?
that the power resides in the
The
people.
people remain sovereign. The people remain sovereign. Not a fictitious entity, not a corporation, not a government, but the sovereignty remains among the people. But the people keep looking over here, talking about you gotta protect my rights. You don't have none over there. Can't nothing and nobody protect your rights but you. And I told y'all that 1,000 times. And the only way you can protect your rights is to know the law. But y'all think y'all coming in and hear me babble for a couple of hours, that's gonna get it? Ain't happening. All right, the territory of two more jurisdictions, hence that branch of jurisprudence arising from diversity of the laws of different nations, states, or jurisdictions in their application to rights and remedies. And all of this is in maritime, all day long. Whenever there's a dispute between two nations, why can you not have that over here?
Way outside their jurisdiction. Yeah,
Because they're not courts.
that's it.
If you, and I'm telling you just how I hear it all the time. Oh, we don't deal with that here. You gotta go somewhere else. You gotta go to the federal court to deal with what, international dispute. They tell us that all the time. But we ain't paying attention. We mad at them because they done told us what, we in the wrong venue. So they told us, oh, well, son, you gotta take that over to the federal court. We don't deal with international issues here, we can't. And they went. The only thing they can deal with here is their property, their slaves. Bingo. Other jurisdictions, the acts in the particular cases of settles the degrees of force to be according to the law of another jurisdiction, the acts or rights in question having arisen under it, either where it varies from the domestic law or where the domestic law is silent or not exclusively applicable to the cases in point. That's y'all right there. The domestic law is silent because the people are silent. Because the corporation has run rampant and made you think that it is something other than what it is, which is a private corporation. The domestic law varies from the domestic law where the domestic law is silent or not exclusively applicable to the case in point. In this sense, it is often called private international law, a term adopted by Westlake, by Woolsey, International Law 5th edition, and others, and characterized as handy and manageable, but at bottom inaccurate by dicey conflict of laws. Moores, who point out that the defects of the name conflict of law is that the supposed conflict is fictitious and never really takes place, and that the expression has a radical defect of concealing from, stop now, conceal
View of circumstances.
Where are you?
View of circumstances.
Where?
View of circumstances.
Where you at?
Concealing from the view of
Okay,
circumstances.
conviction law never really takes place, and that the expression has further radical defects of concealing from the view the circumstances that the question by the laws of what country a given transaction shall be governed is often too plain to admit of doubt. Now, going back to again that paraphrase, we read that in what earlier? The law of what country? We read that where? In the law of the flag. The purpose of the flag is to give notice under what law you choose to contract. Giving notice. And that's what this whole law is dealing with. And the reason why that particular entity choose to call it what they call it is because they're basically saying that this, when you call it the law of conflict, basically is actually private international law, which is why there's a dispute between nations. But it's conflict of laws, which is another term for private international law. And just putting this term in a document really makes them pay attention. Because you just gave them notice that you didn't beat the coup. You're no longer stuck. And if you choose to force a contract on me, then by the right of law, I can enforce a contract on you for fraud. And now I can take you into the right venue and collect. The transaction shall be governed. It is often too plain to admit of doubt if he says the term applies to the conflict in the mind of a judge as to which of the two systems of law should govern a given case, This amounts simply to saying that the term conflict of law may be used as an inaccurate equivalent for the less objectionable phrase choice of law. Tailored jurisprudence, considering the opinion of many writers, concluded that the term private intellectual law is subject to many objections, yada, yada, yada. Scroll on down, let's go to the, get into the process.
So in your case, in your paperwork, do you use choice of law or conflict?
Choice of law.
You use choice of law instead,
Choice
because
of
it's
law.
less objectionable?
Yeah, use choice of law, use the, if you look up the Illinois codes, Illinois has codes for choice of law and common law. And it actually says that all judges shall give notice, judicial notice, to the common law. Well, it's in the codes. It's in the codes. What is the administrative process? Definition for the administrative remedy. Administrative remedy, a non-judicial remedy provided by an administrative agency. Ordinarily, if an administrative remedy is available, it must be exhausted before a court will hear the case. Now it all makes sense. What court are they talking about?
Your court.
No.
No.
I'm talking about my court.
Admiralty,
Say it again.
Admiralty Maritime,
Because that's the only way the court is.
out of three.
See,
Right.
my happy ass part of my expression, I exhausted the remedy and took it over here, and the contract clause got raped. I was like, hold up, dude. It says right here, administrative agency cannot interfere with the contract. Judge was like, psh, psh, psh. I'm like, oh, okay, I got you. I got something for you too. But he basically ran over my contract against this corporate entity. Oh, he had the right to. I made the mistake of thinking that I was in the court. I did. Exhaustion of the administrative remedy, you can now go into the court. And when you look at all the lien processes in Admiralty Maritime, it's sweet. Exhaustion of remedy, the doctrine that if an administrative remedy is provided by statute, a claimant must seek relief first from the administrative body before the judicial relief is available. Scroll on up. Now, this actual piece was coming from the Attorney General's site. I keep forgetting what that site is, but it's all the stuff that they never dealt with. And I like to go there because if I see how they fight a case, I see how they attack it. I look at what their defenses are and just remove them. Because a lot of times they tend to think that they're above the law anyway. But I like knowing how my opponent is going to defend if I'm coming at them. And it changes everything because you already know ahead of time what they're going to do and how they're going to do it. Exhaustion of administrative remedies. The doctrine that if an administrative remedy is provided by statute, relief must be sought by the administrative body before it can be, you can get it. Come on up. And again, all we're talking about is the process for private contracts. That's all it is. The law of contract. It's a procedure. The administrative process is a notice of fault and a default. And you now have a contract, a binding contract by which you can compel performance.
Too far.
Come on up. Come on up.
You want to keep going?
Yeah. This is just a lot of the repetitive stuff. Exhaustion of administrative remedy simply means that you have given all parties involved a due process which consists of notice, legal notification required by law, agreement, or imparted by operation of law, as a result of some fact such as the recording of an instrument with definite legal cognizance. Means I gave you the awareness that a suit was being commissioned against you and had it behind you. I gave you a second due process, an error of defect or judgment of conduct, any deviation from prudence or duty, resulting from the inattention, incapacity, perversity, bad faith, or mismanagement. Come on up. Cure, to remove legal defect or correct legal errors. You failed to respond, so I gave you a fault with opportunity to cure. Fault of omission, negligence resulting from a negative act. Default, the omission or failure to perform a legal or contractual duty. Default judgment, a judgment entered against a defendant who failed to plead, or otherwise defend against the plaintiff claim, often by failing to appear at trial. Now, I sent you a notice of fault and a default, and you failed to respond, right? Was that not a trial taking place?
Yes.
Did I not send you out a summons in the form of a notice? Did I not send you out a second notice, fault opportunity to you? And you failed again to appear, so now I got a default judgment. Now you got a contract. I have a contract.
So if a police, if you, work an administrative remedy on a police officer, should you, find his home address and notice him?
No, you ain't got to find his own address.
Doing business as.
Doing business as. Well, you can send it straight to his office of employment.
So you said it's in police headquarters?
Exactly. They know who the hell he is. All you got to do is send it there. Yes, sir.
So a default is like a warning, right?
Ah, not the default, but the true bill.
Yeah.
I said it 1,000 times. True bill is a Fourth Amendment warrant, Fifth Amendment bond. And it is. If I got my process done in that financing statement is called what? Anybody know what it is? If you filed your lien on a financing statement?
It's
Huh?
it's account receivable.
Accounts receivable. You be quiet. See, he's at the crib and I'm going through all of this and he's hearing me, so he's repeating. You don't answer. You be quiet.
Fifth Amendment what?
Accounts receivable. Huh? James, do you remember the brother in Detroit, Rashid?
Yeah,
You remember how much his lien was
$40
for?
billion, because he submitted one of those documents that.
30 billion.
To discharge the debt that they had against me for the home. They took it and they didn't return the document.
The brother had a $30 billion judgment. $30 billion judgment.
Yep. They are for us.
Huh? And he issued promissory notes off of that judgment
Okay.
to discharge debt on people's behalf. He did. That's why I mentioned that. He knows the person.
That's slick, that's slick.
No, that's the law. It's called accounts receivable. I can issue payments, I can give you a check off that instrument, and you have the right to go and deposit in the bank all day long.
So does that instrument have to be filed somewhere for the bank to verify that it exists?
Yes.
Financing statement.
Yes.
Okay,
Yes.
I got a financing statement. I got the ultimate document in the land of commerce.
Hell yes.
It's called accounts receivable. That's money. That's what, when I say money in the bank, that's money in the bank. And this is why he can issue these commercial instruments. Because that's all money is. When you understand how the whole game is played, what is backing Federal Reserve notes?
Your energy,
Something's backing, yeah, something is.
the faith, and
The assets and business.
your ass.
All of that.
All of your
All of
ass.
that and then some.
All your ass.
There is,
My ass.
every Federal Reserve note is underwritten. And like if I wanted my corporation to issue bonds, I would have to go to an underwriter who's going to give me an insurance policy to insure my bond. Every promissory note that we as American people sign for houses and cars, birth certificates are the bonds that is underwriting the Federal Reserve notes that they put out into the public. That's the only way they come out.
It's an
So-
insurance route.
My financing statement is a commercial bond that is underwriting the promissory notes that I now issue out. And it's all lawful. It's securities. That's all this thing is about, paper. And what money is. Money is any piece of paper that has the proper negotiable language on it. Huh?
Is that what they learned in Series 7 in insurance?
Well, some of them do, not all.
So
But I mean, that's what we're doing now.
Yes. Why did, do you know the biggest industry in the legal field right now, lawyers are buying debt so that they can come after you, the general public, and rape them. Because they know for the most part the general public is ignorant. I often consider being a debt collector. Because I can clean up. Y'all can make me rich. By not paying these little bills. You'd be surprised. Because you can lien and levy all day long. I can garnish sheet.
So if we, people basically stop signing our birth certificates, we can roughly put the corporation in big trouble. I'm saying every time we have these kids, we don't sign the birth certificate.
Oh my goodness. Yeah, you about to raise start water. About to start water.
Another war.
Yeah, another one, exactly.
Yeah,
I've had a few people
war against us.
I've had a few people call me to show up, you know, with them or come to the hospital to try to take the baby out. They calling the sheriff now.
They want us to take the baby?
Oh, they madness. Let me just ask you, is this your child? Is this your child? Is it yours? Then please, no, there's no more conversation needed. Anything else you have to say, please put it in writing. I'm here. I will take it up with the attorney.
So, and even so, if the husband will bring their Bible and they record that birth in that Bible.
That's all you have to do.
Right.
That's all you have to do. Because, right, what happens now is the Social Security card is already attached to the birth certificate. You don't have to fill out a Social Security card for your children. It's attached automatically.
You bring your old new Bible with your Bible.
Yeah. You have 3 witnesses. But that's the best way.
Could it be a
What happened?
Quran?
Oh,
Could it be a Quran?
Yeah, it could be any, whatever your religious belief is. There's no, they can't dispute your religion, but it's simply, if you record it, it's totally legal. As a matter of fact, we found some case law for a friend of mine in Tennessee, because they were giving her a lot of harassment. And I said, no, the affidavits are lawful all day long. I'm with them what they tell you. And I sent her, email some case law, I said, now put that in their face and then ask them what they have to say. And they did what was requested. But see, they'll play on your ignorance all day long. Scroll back down. They'll play on our ignorance all day long. But an affidavit stands as truth in commerce, and nobody can dispute it. Especially after if you were given notice. You only have so much time to dispute it. Come on up. Yeah, they get jiggy with it now. I mean, the last 2 nieces that were my nieces' 2 kids, we had to go and threaten them to come out there with the placenta. The nurse tried to run off with the placentas. They are not playing. You know, we don't realize there's. I've been telling my family for years, y'all on the food chain. And one day y'all gonna wake up and recognize. And I'm gonna tell you what freaked me out in the last 3 weeks. I've had 5 of my nieces and nephews call me talking about expatriation. I said, well, wait a minute. This that crazy ass uncle you talking to. No, you're not. My niece talking about, look, I'm coming up there in 2 weeks and I want you to get my shit done. Because they putting up, she's talking about they over where she live at, they putting up some blockades near the highway. I said, well, told you. Told you. But this that crazy ass uncle, I know you ain't calling me about no expatriation. I mean, I got 5 that blew me away. All right, where we at?
it's spun down.
Spun down. Okay, default judgment. Look it up. I gotta get a remote. That's what I gotta get.
Oh, actually, I'm not using this, huh? I keep using that
I'm
doggone
gonna get a
thing.
remote. That's it. Go back to the other default judgment. No, up. Go that way. They use the remote and his finger all at the same time.
There you go.
Let's deal with this one. Default judgment is being sought against you having waived the right to answer by acquiescing, tacit admission and failure to contest, rejecting your due process. See, all of this is within the common law because you must have your what? Your due process. No one can deny your due process. And that's what the notice of default is, your due process. In absence of such response, affiant hereby inserts and records the notice of default upon you and against the above named respondents pursuant to the Constitution, Article 1, yada, yada, yada. Judgment by default is a judgment rendered in consequence of the non-appearance of the defendant. The term is also applied to judgments entered under statutes or rules of court for want of affidavit or defense, plea or answer, and the like, for failure to take some required step in the cause. Every state has in its codes that if you do not deny, you admit. Now always throw that in there. If you fail to deny, then your acquiescence is your admittance. All of this just helps seal the contract. Consent judgment. A judgment, the provision and terms of which are settled and agreed to by parties of the action. It means that everything you accuse them of, they agreed 100%. Scroll on up. Consent judgments are in effect merely contracts. And now you have the power to compel funds. That's all this stuff is. It's all contract law. Hold on, where you going? Moving too fast.
I got a song for that.
You had coffee or some sugar something.
Yeah, a whole package.
A bunch of
No.
cookies.
Just bouncing
He ate
all over the
two-thirds
place.
of a package of cookies.
He had the cookies.
You on a
That's like
roll,
that
ain't
kid right after lunch.
Yeah.
You must have had some sugar today.
Yeah.
Consent judgments are in effect merely contracts
My
acknowledged in
cocaine
open
habit.
court and ordered to be recorded, but as such, they bind the parties as fully as do other judgments. Now, what makes your judgment more powerful than this one here?
Under penalty of perjury, a signature.
Affidavit
And what is an affidavit?
stands as true.
In where? In commerce. And man, if y'all really understood those 10 maxims, that is the law. An affidavit is the most powerful document in commerce, and they don't never sign no affidavits.
So therefore, you saying that when the corporation sending out their notice fault and defaults, they're like a colander, they have a bunch of holes in them that you can basically.
Man, it's like going to the well and coming dipping your bucket in the well, and by the time you get up the hill, it's empty.
So theirs can't hold.
They can't stand. They have no standing. Can't hold water. Exactly. There's a hole in the bucket. It ain't just.
Dear Liza, dear Liza.
It's a serious hole in the bucket. There's a hole in the bucket. The judge nor the attorney has sworn and attested to anything. These are just statements on paper.
We are the children of one father, and the breast of one mother hath given us suck. Same blood, don't believe in love, but remember the relation that binds us to unity and love. May the blessings of our fathers contribute to the support of us. Happy is the man who has sowed in his heart the seed of benevolence. January 8th, the prophet's anniversary. I love to see the Moorishness. Moors are the closest. Talk to Allah face to face like Moses, and he tells us heaven. Allah chose us, we prayed, he heard us, sent us a prophet, now look at us. Hope our children learn to be industrious.
The prophet said the Moors once fed the world, we gotta do it again, hey. The prophet said the Moors once fed the world, we gotta do it again, hey. The prophet said the Moors once fed the world, we gotta do it again.